we talked about different youth justice acts in Canada. And so when we're going through these acts, students should be able to know the general era of the act, how that act viewed criminal behavior and what its purpose was, and some of the limitations or criticisms that led to its downfall. So from 1908 to 1984, Canada had the Juvenile Delinquents Act, where youth were viewed as delinquent rather than criminal. They received dispositions rather than sentenced. And they were responded to with these dispositions for the purposes of protection, treatment, and rehabilitation. But unfortunately, protection and treatment were kind of influenced by the child savers, and this was often in the form of indeterminate sentences where they were effectively trying to have the youth change their culture and their, for example, religious beliefs. So Catholic youth were targeted and Indigenous youth were targeted. And back then, there was not so much of a concern for due process, which meant that youth often received disproportionate punishment and often in the form of indeterminate sanctions. A lot of criticisms with the JDA, one being too much judicial discretion. That's in relation to some youth would be transferred to adult court, others would not, even though they committed the same offense, and we could see how minority youth would be more likely to be transferred to adult court. We also had a very broad definition of delinquency at that time, which included status offenses, which are an offense for which a youth can be punished, but not an adult. So, for example, drinking would be an example of a status offense. Skipping school or incorrigibility, all examples of status offenses. The maximum age at which somebody would be responded to through the JDA also varied by province, speaking more to that issue of judicial discretion. And we saw, for example, some people believing that the JDA was too strict and others believing that it's not strict enough. And these are sort of some common themes that carry forward to the YOA and the YCJA. So after the JDA came the YOA that ran from 1984 to 2003. The Charter of Rights and Freedoms was especially instrumental in why the Young Offenders Act came about. Some of the issues were, for example, the use of status offenses. And the use of status offenses was believed to be a violation of a youth's Charter of Rights and Freedoms. It's like cruel and unusual punishment, where we're going to say that youth are not as responsible for their behavior as adults, but we're yet going to punish them more severely than adults for certain behaviors. Indeterminate sanctions were another sort of violation of charter rights. To sort of try and address provincial disparities, the minimum age was raised to 12. And again, the YOA sort of explicitly acknowledged that, youth are criminally responsible, so we now are going to have sentences as opposed to the JDA that had dispositions, but we also acknowledge that they're not responsible to the same degree as adults. So the Young Offenders Act had kind of two purposes. One was to divert non-serious offenders, and the other was to incarcerate serious offenders, and the idea was that this would help rehabilitation for both groups. But part of the problem was a lack of specificity under the YOA in terms of when diversion should be used and when incarceration should be used. And so the YOA went through 3 main amendments. And you don't need to know the nitty-gritty details of each amendment, but you should understand that the first amendment emphasized procedural amendments, so figuring out when and how youth will be transferred to adult court, when youth would be detained for pretrial detention as opposed to released on bail. The Get Tough on Crime amendments were basically just about cracking down on individuals involved in really serious offenses by raising the maximum length of a sentence that a person could receive for offenses like first and second degree murder. So the YOA was replaced for a lot of different reasons. Again, it failed to address judicial disparities between provinces. Conservatives saw the act as being soft on crime. Despite conservatives seeing the act as soft on crime, under the YOA, Canada had the highest rate of incarceration of youth compared to any other Western industrialized nation, including the United States. And part of this was because of an overuse of pretrial detention. Despite the procedural amendments, there were still unclarities regarding the process of transferring youth to adult court. We also saw paternalistic or at least protectionist sentencing practices where girls were more likely to receive more punitive sentences compared to boys. So now we get to the YCJ, which was still ongoing but was introduced in 2003. and it reserves its most serious interventions for the most serious crimes, and wants to reduce the over-reliance on incarceration for non-violent young persons. So it's trying to do exactly what the YOA wanted to do. The difference is that it's a little bit more effective. They dealt with the problem of being unclear about how and when to transfer youth to adult court by saying, we're no longer going to do that. So they got rid of transfers to adult court altogether. And instead, they implemented the possibility for adult sentences. So once a youth was convicted of a crime, then there could be the possibility that they would be sentenced as an adult. The YCJA tried to address the ongoing issue of the YOA in terms of the overrepresentation of Indigenous youth by creating Indigenous-specific sentencing policies. And a lot of you in class focused on that as part of your presentation topic, and I think so we all now know that that wasn't very successful. But the YCJA was fairly successful in reducing the overall rate of incarceration. Of course, it wasn't hard to do because the rate was so high under the YOA. But one of the ways that the YCJA was able to reduce incarceration was by being more explicit to judges about when incarceration should be used. So under the YOA, judges didn't know, when should I incarcerate? When should I release on a community supervision order like probation? So the YCJA basically told judges, look, there are only 4 conditions in which you can even begin to consider using custody as a sentence. So a youth can only be sentenced to custody if they have committed a violent offense or if they have a history of administrative offenses. Those are crimes where they're violating a court order. They can be incarcerated if they have committed an indictable offense and they have a history of prior findings of guilt, 2 or more crimes. And an indictable offense is an offense for which an adult could receive 2 or more years in custody. And if they don't have a prior criminal history, if they have committed an indictable offense and that indictable offense is associated with aggravating circumstances, then that person could also be sentenced to custody. But the key is could be. For each of these 4 gateways, the judge must consider whether any other possible sentencing option would be suitable for promoting rehabilitation as opposed to using a custody sentence. So a custody sentence is supposed to be used only as a last resort. So there's still some criticisms of the YCJ. Some have been dealt with or are not fair criticisms, and others are fair criticisms. So an initial criticism was that the YCJ was too complex and that people thought that probation officers would have no idea when to recommend particular types of sentences, when they should recommend to Crown Counsel that a person be charged for breaching their probation order. But studies of probation officer decision-making show that they have a really good understanding of the YCJ and they've been able to understand this complexity. One of the persistent issues in terms of like the UN Convention on the Rights of the Child is that the UN says we shouldn't be naming the names of young persons who have committed crimes, but the YCJ allows the justice system to do so if the youth has been sentenced as an adult. We still have not addressed regional disparities and probably never will when provinces are the ones responsible for paying for the implementation of the youth justice system. And certain groups view the YCJA as being soft on crime and being basically a failure. Don't know if it's necessarily accurate given the reductions that we've seen in the rate of crime. So it's not just about youth justice legislation, it can also be about models of justice. And I talked about 5 different models, and you can see here they're organized on kind of like a political ideology spectrum, the welfare approach being more left-leaning, the crime control approach being more right-leaning, the modified justice approach, which is what Canada currently uses for the YCJ, is kind of at a balance where for the least serious forms of offending, the emphasis is diversion. For moderate offenses, the emphasis is community-based solutions. And for serious offenses, the emphasis is custody-based sentences. So students should have a look through each of these 5 models and be able to identify, for example, the time frame that they were used in Canada, their perspective on why crime occurs, their position on how to respond to such crime, and who the key players are in the justice system responsible for sort of carrying out the effectiveness of that model.